You're listening to the Subrogation Support Network, a podcast from Matthiesen, Wickert Lehrer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, everybody. This is Ashton Kirsch, your host with the Subrogation Support Network podcast. Thank you all for joining me today. We have a fascinating topic. Today, I am honored to have attorney Lee Wickert joining me today. Lee is an attorney, used to be up in Wisconsin, now down with our Austin, Texas office. Lee is an amazing attorney. He's kind and patient enough to work with me, which is saying a lot. I'll tell you a little bit about Lee and I'll let him introduce himself, but Lee is actually an integral part of our firm. He manages the coverage the coverage book we publish. And he's also, travels around just like I do, speaking at conferences, meeting clients. He's an amazing attorney. He's even written an article that was recently published in the New York Times, similar on a topic we're going to talk about today. It's titled, Who's at Fault? Read the Fine Print to Make Sure You're Not at Risk. Talking about exculpatory clauses and other things tangentially related to releases. Today, we're going to talk about a fascinating topic. We're going to discuss the ins and outs and in-betweens of releases, how to negotiate releases, the subrogation claims primarily, what the important clauses and factors to think about and look out for will be, and so forth. But let's jump into it. Lee, how are you doing today?
Hey, Ashton. Thanks so much for having me today.
Hey, thanks for joining. So, Lee, tell us a little bit about yourself. Tell us about the practice that you're doing and what you're handling down in the Texas office.
Yeah, it's been a fun adventure down here in Texas. I got my legal start in the Milwaukee area. I went to law school at Marquette, practiced in Wisconsin for 3 years out of the Wisconsin MWL office, but then had an opportunity to head down to Texas and start the Austin branch for MWL. So I was the first employee down here, was in a fold-out chair and table, and slowly built this growing branch. We're up to four attorneys actually, and 3 support staff. So it's been a booming market in the subro world down here in Texas.
Do you still have the folding chair, or have you been upgraded to a desk?
I actually lent it to my mother, who recently moved into an empty house. So she's using it for her office. It lives on.
Well, glad to hear you have a desk now, Lee.
Yes.
So what kind of work are you doing down there in Texas?
All sorts. We're having a lot of auto subro is the big moneymaker right now for us. There's just a lot of people coming to Texas, moving to Texas. One of our newer clients is a younger insurance company that started small locally here in Texas, Germania Insurance. Shout out to them. But it's been fun growing alongside them as they expand from a mostly rural farmer market to now an everyday insurer of auto and property subrogation. So we're kind of establishing roots here with other Texas-based insurance companies and really carving a name out for ourselves.
Excellent. So I just had Mark Solomon, you obviously know Mark, on the podcast for our last episode, and we talked about we were talking about steer claims, counting in the roads, all that fun stuff that you hear, and we went into depth on Texas and just the sheer size, the landmass, and the extent of claims. And yeah, auto is a huge thing down there because there's roads everywhere, and people are crashing into other people, and also cows apparently.
That's right. And we get emails every day about Mark's cow chart. It really just speaks to the flavor, the culture of Texas. I'm learning more and more about it every day, exploring different parts about it. But it's just the people down here, you feel it everywhere, even in the food. We just got barbecue for lunch. You can't beat it.
Yeah, we there's no barbecue good places up here. So are you wearing cowboy boots yet?
I have. I grew up, my father, Gary Wickert, he wore cowboy boots my whole life. So I always kind of picked up on that. And I even wore them up in Wisconsin. I recommend it to everybody because it adds 1.5 inches to your height. Pro tip.
I'll have to come down there and get a pair of boots one of these. So, all right, let's jump into the topic. Enough of that. So let's talk about releases, right? So today the goal is to talk about those things, the tips and tricks. And obviously, Lee, I know that you've spoken on this before, given presentations and webinars. And, give me some details. Why do you think understanding releases, reviewing releases, actually reading the language is so important to any adjuster or attorney handling subrogation claims?
Yeah, and I was excited when you reached out with this topic, Ashton, because releases is something nobody likes dealing with. It's an icky topic. It has a lot of legalese and fancy old English words that kind of make your eyes go cross. But releases are involved in almost every one of our subrogation claims. It touches almost every file. So just the sheer volume of these releases, it becomes a very important aspect and one that shouldn't be overlooked just because it's kind of a headache. I'll admit, I look at some releases and I go, oof, I don't know what they're trying to say here. But those are the most important releases to sit down, dive into, and figure out what you're actually releasing. Because that's what a release is. You're giving up voluntarily certain rights to bring future claims or pursue a further pursuit of a lawsuit in exchange for money, of course.
Wherefore art thou for all men present thereto thou shalt. I mean, there's sometimes you see some of these words that I swear, I mean, it's like reading Shakespeare at times. But we have to do it, right? That's why people pay attorneys. I mean, but adjusters really need to learn. I think that's the big thing to note as we enter this topic. It's just take the time, read these releases. I have seen countless releases where obviously there's all the time redundant because ultimately a lot of times these adjusters, they're not reading them. They didn't draft them. Frankly, it was passed down from their great ancestor of subrogation claims of, 40 decades past where, they were using their predecessor used this release and the next guy used this release and, the person handling it before them used the release and next thing you know, it's in their hands. They have no idea. So that's where a lot of times, by reading these things, we can find terms that are irrelevant. Oftentimes, frankly, most terms are irrelevant, but also those terms and those clauses that could have a major, a hugely negative impact on how we pursue these cases, right? And we'll talk about indemnification language, hold harmless language, confidentiality clauses, who's actually being released, right? This can be a huge problem. I recently had a client who sent me over some of there was this release, right? And it had just that language, the wherefore art thou all men present, and all of these things that frankly are just ridiculous old English that shouldn't be there. But also there was language in there that the release was so broadly applicable that it said we are basically releasing, the insurance carrier is releasing the other insurance carrier and they're insured for all claims in perpetuity, right? What does that mean? That means that this was actually a $5,000 water supply line case. They're arguably opening up exposure to release all past and arguably all future claims that this company, which is a big carrier, has against this other company, who is one of the top 10 carriers. Obviously, we go back and forth. I could argue that that's not going to be as broadly applicable and that they didn't have the authority to enter that release, but that would require huge litigation. And, whether these adverse adjusters are putting that language there purposely to try to get a gotcha, or it's just assumptively and probably what it is it's an accident and it's just, they're trying to be as broad as possible, but it can have a huge impact, right? We're talking about billions and billions of dollars of impact. There's a lot of cases, and we'll go into some details on bodily injury language, right? A lot of times PD releases may have bodily injury language in there where you're resolving your $2,500, fender bender. And next thing you know, you're opening up an indemnification for the defendant if that injured party then makes a personal injury claim, right? So that's why we need to be so careful. Right, Lee? Any comments?
Well, yeah, and I'm glad you brought that up. These releases are often, and I do it too, are a result of that copying and pasting of language. It just, when you, an adjuster, get a release, 9 times out of 10, that is just a release they used on a previous file. There's no intent to include this indemnity language. And that's why it's so important to review it and to ask, to seek that out and see if we can narrow in that release language and modify it to a more appropriate use. Because like you said, just taking the quick way out, signing at the bottom and getting your quick check can have catastrophe of a result. Millions of dollars could be lost if you're on the hook for this indemnity, for this duty to defend, especially if you're a multi-million dollar insurance carrier. I mean, the results can be horrible.
So Lee, what are the most essential items that adjusters should be looking at and reviewing and considering when they're taking a look at these releases?
Well, first and foremost, it's the terms. Make sure you've got the parties appropriately defined. Make sure the dollar figure is accurate. Make sure they're describing the event in appropriate detail. And a release is you are voluntarily giving up rights pertaining to a certain incident, a certain claim, a certain loss. If that loss is not appropriately defined, that release can be extraordinarily broad. So start there. Make sure the terms are correct. The next big ticket item you want to look out for is that indemnity language. Indemnity simply means it's one party agreeing to indemnify another, protecting them against future damages that might be incurred from the release party or any threat of future civil litigation. So you're agreeing to protect that other party from future claims. You know, what that means is if someone, not you, decides to sue that third party that you're releasing, you're on the hook to make them whole, to pay for that defense. The ramifications can be millions of dollars. So indemnity language is the big one. And later on, we'll go through ways to negotiate on those, what those mean, certain language, what can be avoided. Other key points in a release you want to look out for is the duty to defend. This is, again, putting obligations on you that you will hire defense counsel for that released party if they become subject to a future lawsuit. I've also seen in those duty to defend language pertaining to choice of a lawyer. So not only is you have a duty to pay for the third party's defense counsel, that third party gets to choose which counsel they get to pick.
I'm sure they're not going to choose some, $125 an hour defense attorney in those situations.
They're handpicking the best lawyer they can find, and they aren't cheap.
Yeah, that's the truth. I can say that when it comes to, the work comp realm, I think this is with the overly broad language and the indemnification, and I'm sure you'll touch on this in a minute, but this is where I see this most often. I probably see this every week where I have to go back on these claims and renegotiate a release where it's in a state we can settle the work comp directly and independently with the adverse carrier, be it in a state like Minnesota with a reverse nag or states where you can just straight up do it. We'll have a small little work comp lien, $5,000, $10,000. Next thing you know, we get back that release. And that release has language saying that we are agreeing to defend and indemnify the defendant, for any and all claims related to this injury. So that obviously includes, one, liens. Also, two, it arguably includes that personal injury claim. And if we don't remove that language, we could be on the hook for a little $5,000 case for maybe the full, $500,000 personal injury claim. So that's why this is so huge. And that's probably, there's a ton of different places where this can apply, but that's where we see it most often and most pronounced.
And that was going to be one of my first tips. When you get these indemnity or these releases that involve indemnity, put yourselves in the adverse party's shoes, that defense carrier. They're going to put in that indemnity provision. Why not? Why wouldn't they? That you might sign it, and that's great for them because now they're indemnified. It's on you to say, hey, no, that isn't appropriate. Let's get that out of here. But the first major tip when dealing with these indemnity agreements is recognizing the claims that you own and only agreeing to release another party for those claims. Like you mentioned, if you've only got the property damage for a car accident, don't sign a release that releases personal injury. You don't own those claims. You don't control them. You have no idea if that driver has a sore back, might develop a sore back. It's not in your control.
And we see that I see that probably daily when I'm looking at releases. And first release coming forward, the first one from the defendant is going to be just a broad term release, right? Even if it's PD only, it'll include everything and anything, Medicare language, Medicaid language, bodily injury, indemnification provisions, and all of the above. Because, why wouldn't you, right? I have a history of doing some commercial, you could say commercial defense work. And in those cases, I'm always going to ask for the broadest form release possible because why not, right? That's my job on the defense side. Similarly speaking, it's our role as subro counsel to jump in there and negate that language, take it out, make clear this was never negotiated. The overly broad language is, absolutely not going to be applicable to a PD only claim. If we have just an auto case for $5,000, why would we ever agree to open up exposure on anything other than that? So I always recommend clients, you can always reach out to Lee and I, but we have just template form releases that oftentimes, either we'll negotiate the terms of the release, but quite often it's just going to be so out there and it's going to have all that archaic or, antique information or languages, clauses. And then we'll come back and say, hey, we're not agreeing to this. We settled at $25,000 for property damage only. Here's a standard PD release that has, 2 paragraphs, straightforward to the point, done. But that's the first thing. I totally agree with you, Lee. It's about making sure that we limit that language, to get rid of any broad terms, make sure we're notifying and having the right parties, the right dates. Incidents are hugely important. We want to make sure that the incident is specifically defined either above. Quite often they'll just refer to the incident, right? Mm-hmm. We want to make sure that somewhere in that release includes what is the incident? Do we have the date range, right? Is there any way that this could be interpreted to include other incidents or other claims? So definitely something that's very, very important.
Well, and you mentioned reaching out to subrogation counsel. I just had one last week. It wasn't a case we were handling, but it was our client has settled a water loss claim, got all the way up to the release, and she just wanted my thoughts. Hey, what are your thoughts on this release? And it was appropriately defined just to the property damage for this water loss case. However, you got to think through this. There might be a future mold and mildew claim that our client was being asked to release. They've got no power over that. So we built out a little exclusion for this indemnity agreement involving mold and mildew. It can be sneaky stuff like that you need to watch out for.
Right. And I'm going to go back to the article that you published on releases. And there's an interesting example here. And you include some proposed language that would come forward and how we'd modify it. And I'm just going to read it because I think that it is very helpful to take a look at it. Now, the proposed language that we'd see in that release that we need to change would read something like this. In consideration of the settlement amount, releasers agree to defend, indemnify, and hold the release party harmless for any and all claims, demands, judgments, damages, liens, or liability arising out of the incident, including but not limited to claims, demands, damages, expenses, actions, liabilities, or other obligations that may be brought against the release parties as to medical liens and wage benefits, right? Overly broad. That is going to be a major problem. Modified language, and we'd come back oftentimes and one, either give our own release, or two, come forward with some sort of modification, as an example being, in consideration of the settlement amount, releaser agrees to defend, indemnify, and hold the release party harmless and reimburse for claims, demands, or other obligations that may be brought against the release party as to medical liens and wage benefits and liens payable under the workers' compensation policy. So one, we push to remove, and we'll talk about indemnification next, remove that whenever possible. But if it's necessary to be in there, we can limit it just to those benefits that would be payable under our policy, not applicable to anybody else or anything else. Right, Lee?
Yeah, and Ashton, you bring up a good point. And if you read these articles, you hear us talk, we seem almost phobic of indemnity, and oftentimes we are. But there are instances where you'll have no choice other than to sign this indemnity. If it's appropriately defined, the defense is going to require you to indemnify them for this loss. And so you need you, the carrier, have to choose between the settlement check or signing this release, which happens to have indemnity. So sometimes you can't avoid it. You got to make sure that it's appropriately defined. In these release language, make sure the terms, describing the incident is appropriately defined, and make that choice. Is this indemnity clause worth the settlement check? I've had cases where no, the client walked away from 60 grand because it wasn't worth getting involved in this entangled web of indemnity. They just walked away, and that's totally fair.
Yeah, and that's one question I was going to ask you is just that, should you agree to indemnification language? And I think my answer to that is typically no. In the vast majority of situations, that language shouldn't be in there. It wasn't negotiated in the settlement. We have an oral agreement or even a written agreement if by email exchange. And at that point, it needs to be removed. It's not part of it. But there could be those situations, as we discussed, where it can be applicable. And that's where we just need to narrowly tailor it to the right point.
Absolutely. We always, the verbiage I always use is we'll agree to release and hold you harmless. We will not agree to indemnify and defend you. That's the hard take we typically take, but there are always, of course, those exclusions.
Yeah, and a lot of times the adverse adjuster or attorney responses, it's always really funny to pay attention to how they go for it, because all the time the response that I get is, yeah, I let them know we need to remove this. There's no consideration of indemnification. There's no agreement to indemnify. We agreed to a dollar value, and that is just how it works, right? If I take this case to judgment and I get a verdict against you, you're just going to pay me a check, right? There's no agreement for me to indemnify you for other claims that aren't related, right? So that's a huge thing. But the response oftentimes is, well, Ashton, this is our template standard release. This is all you get, right? This is what it is. I don't have authority to change it. And my response is, okay, well, then I'm not agreeing to resolve with you, and I'm going to enforce our agreement per the terms that didn't include indemnification, and or go back to say, that's ridiculous. You obviously, maybe you don't have the right to change the release, which frankly, I'm sure you probably do. But somebody else within your organization, I can guarantee you, has that authority. And frankly, you probably should find somebody else to re-review this because your release is terrible and includes, this Shakespearean Old English language, and it needs to be updated. Find a good attorney to do so.
Yeah, in my 6 years of practicing and dealing with these releases, I'd say it's like 9 times out of 10, they'll just say, that sounds good. We'll make the change. And it's just no big deal for them. So if you don't ask, you'll never know because they might not care about it. So they're just throwing it in because it's in that form that they are required to use.
Right. Yeah. I mean, it's about asking, right? It never hurts to ask, even on cases where it may be appropriately narrowly tailored. I still always, step one, ask, can we or we need to remove that language, right? There should be no hold harmless. There should be no indemnification. And then we go from there. There's going to be the majority of situations and majority of cases, if they refuse to, my answer is just going to be no, right? We didn't agree to that. We're not going to have indemnification language. And, my experience in having reviewed, frankly, cases handled, we're taking them over from other firms, plenty of cases that were negotiated and fell through by our clients. And, one of my other roles is I do sit down with adjusters and watch them negotiate and then consult with them about best practices in subrogation. And all the time you see them just putting almost no attention into these releases. Maybe they'll push back. And then when they're told, no, it's template, then they say, well, this is too much work. I don't feel like, going back and forth on it. And I would say, absolutely not. Take the time. You do not want to be the one that opens up some major exposure for the carrier because you decided to save 25 minutes of negotiating going back and forth.
Absolutely. And if you think about this from a carrier's perspective, I mean, they are handling tens of hundreds of thousands of claims. If they all have releases with indemnity provisions, you can be dragged back into court from who knows where. Just some random release you signed back in 2005 that requires you to defend and indemnify a different party. It's just not a risk worth taking.
And to make matters even worse in that situation is that any payment made or any defense cost incurred there, that's not going to be applicable to the specific claim. That's going to go back to the actual carriers, to their bottom line, right? So that's going to be it through E&O or some other coverage. They're going to have to go forward and defend and handle that indemnification claim, whatever be it's retaining defense counsel, making payment on it actually, and it's going to hit the bottom line. So this isn't something that we can just paper over and avoid. It's something that could create a huge dilemma and does create a huge dilemma for carriers, frankly, all the time.
It's just important to understand that, and that you understand the gravity of signing indemnity. That's where we encourage you to reach out to subrogation counsel to make sure this is being reviewed. Make sure you're understanding what you're agreeing to before you ink your name to that paper.
Which is, another plug for something I always make clear is, there's defense attorneys and then there's plaintiff side subrogation attorneys. And that's where having attorneys, be it, I'm biased, attorneys with MWL, or attorneys with whatever other firm that specializes in subrogation. That's why it's so essential to have them on board, because this is what we do all day long, right? We don't look at releases from the defense side, right? We look at releases from our side. This is, what we specialize in. So little plug for making sure that you trust your attorneys. Now, Lee, any other clauses that stick out to you as important and worth us reviewing during this podcast?
I did want to bring up one other way indemnity kind of rears its ugly head in the subrogation world. And we've been kind of focusing it at the tail end of a subrogation claim during the release. But indemnity can also come up in service contracts and agreements that your insured has entered into. I mean, look at any car rental agreement. There it is. You're indemnifying that car rental company. That's something good to know upfront day one when you're starting a subrogation investigation. If your potential third party is someone that your insured has indemnified, you might be out of luck on your subrogation claim. Because remember, subrogation, we're stepping into the shoes of our insured. We're pursuing claims on their behalf. If they've released and indemnified the third party you're pursuing, you're out of luck. There is no subrogation claim.
Absolutely. That's why it's so important that, especially for carriers who deal with corporate entities or business clients, to work with and actually educate insureds, right? When we're first negotiating that policy, and I actually have a presentation I give to those adjusters and also to agents on just that. How do we educate our insureds to include the appropriate language in service contracts and any agreements, right? We don't want waivers of subrogation language. Absolutely not. And frankly, that's just, that could be a whole nother presentation. And frankly, it is in and of itself, because there's almost no consideration ever given or benefit given. And they just toss these waivers of subrogation, left and right. Similarly, and indemnification, all of the above, but also on those agreements, Lee, it's really important to note that when you have a case where comes forward, you get all the contracts and you see indemnification language in there between the insured and a service provider that may have caused the damage, get counsel to review it, because there's all kinds of ways for us to argue around it, right? We can argue that it's, too broadly applicable. We can argue against the contract and try to strike the contract. There's a lot of things we can do there. But I mean, on the front end, it would be way better if that language wasn't there or appropriately tailored.
Yeah, last thing I'll leave off on is provisions to look out for in contracts is confidentiality agreements. They're often just dovetailed into releases. Oftentimes, they're not necessary, and they just make a simple release a much bigger headache. You're not able to send it out to other parties. In certain cases, of course, a confidentiality agreement is necessary, but for a simple fender-bender car accident, give me a break. Let's get this out of there and make things simple for everybody.
Yeah, and you have to read the language there, because I've seen this broad, very, very impactful confidentiality language that can include actual monetary damages or real consequential damages that could have a huge impact there. That if it's not appropriately defined, just simply stating that the case settled could arguably be enough to bring about some sort of liquidated damages claim or something else that could have a huge impact. So I always negotiate out, in most cases, confidentiality clauses. And if we do have to include them, which there's going to be large enough cases or complex enough cases where it should be included, or even on some cases where maybe we don't have the facts and it's truthfully a garbage case, but we want to get it done and they just don't want the world to know that they're settling cases on defense costs. Well, sure, we can consider appropriately tailored confidentiality clauses. But another thing I'll note on confidentiality is quite often when they're tossed in at the end and it's not included during negotiations, I'll require that they actually pay something for it, right? There needs to be some consideration. We've agreed to give you a release that we're not pursuing you for these damages anymore. We didn't agree to give you any sort of confidentiality or have any other sort of positive rights there or negative rights. So, I think that that's something to keep in the back of your mind, that there is no inherent requirement that we agree to keep things confidential, and it can create a total nightmare down the road if those are too broadly applicable.
Yeah, that's interesting. I've not had to deal with that, but that's a great practice tip. Speaking of practice tips, I did want to say, make sure you're reaching out, speaking with your insured, and having them contact you prior to signing any releases that may or may not involve indemnity. Just your insured can waive the carrier's rights. I was just we've got an article about a marina fire out in Massachusetts, and of course, it's got an exculpatory agreement, which is very similar to an indemnity. Everyday people see exculpatory agreements. You see them when you take your kids go-karting, or I went floating down the Pedernales River, and sure enough, there it is. They're asking me to release the company for any and all losses or damages that one may suffer. Well, and think about that for a second. What are they asking me to release? Any and all losses. I mean, that includes gross negligence. That includes an employee coming up and just sucker punching me. I mean, that's not right. I mean, we've got a chart going over all the exculpatory agreements, if they're enforceable in which states, the requirements for if it needs to be bold, what type front it needs to be in order to be considered enforceable. It's important to understand for this marina fire, the way we got around it is, instead of arguing Massachusetts law, which allows these type of exculpatory agreements, we argued admiralty law, the law of the sea, and took it kind of federally to try to sidestep this issue totally. Just an interesting case where these kind of exculpatory agreements and release language can come and kind of muck up the waters.
Yeah, it's very interesting. But I just got caught up on just envisioning you about to go on this nice boat ride and then just getting punched in the face. And I keep thinking, what did you do? Did you deserve it? I'm
yeah. Well,
playing through it in my head right now. So
one of the side effects of being a lawyer is you get these pieces of paper and people always look at you and they go, well, you're a lawyer. You should have read it, right? So if you sign it, I'm safe. And you read the thing and I go, well, this isn't enforceable. I'm going to sign it because no way this is holding up in court.
Another consequence of being a lawyer is that people just want to punch you in the face. So
hey, I'm just trying to enjoy it. Yeah.
Yeah, and also commenting on that is you mentioned, asking the insureds to contact us before signing releases. I would say at least monthly, if not more often than that, I get cases from clients, just slam dunk, beautiful cases, primarily on the bodily injury end, work comp. Next thing we know, we take a look and, oh, wow, 6 months ago, the insured signed a release for totally releasing our claim and making us, obviously have to go against them. And, oh, wow, it was a tiny little settlement. So we're limited to, whatever it could be against an uninsured insured who's probably not going to pay us a dime. So that's why it's so important. And to get those things and ask the question soon, because frankly, if I have that in the claim file and I can take a look at it, beautiful. I can tell the client, sorry, you're out of luck. Better luck next time. But if I don't get that, if no one's asked for it, I'm going to ask for it right away from plaintiff's counsel or whomever it could be, or even the defense attorney or defense adverse adjuster. But there's times where you get to be down the road, right? We're in litigation. We've retained experts. And next thing we know, we find out, oh yeah, the insured settled for this marginal amount that had language that was broadly applicable and your case is done. So that's where I always think it's so important that first party adjusters, primarily the frontline adjusters, are aware of these things, that they're trained up in reviewing releases. They make sure that they tell the insured, always, always, always get me that release, because that's hugely important. I can tell you on just the other way around too. Right now, I have a case that I'm representing, an injured party on, right? It's a family member. And their carrier is frankly also, they're pursuing subrogation on it. And I've made clear to them, hey, when you enter into an agreement, I need to review that release, because I know full well that if the adjuster, the individual doesn't know what they're looking at, it can spell trouble. So, obviously we need to be educated, but we also need to make sure that our insureds or anybody else related to us in those claims are also educated on these things.
Yeah, and that's a real threat of, third-party insurers. If your insured gets in a car accident and kind of is roughed up, but, not too bad. He doesn't want to hire an attorney. It's a legitimate business strategy. I've had friends reach out to me. My wife's in a car accident. This other insurance company's reaching out. They're offering to pay $5,000. I mean, that's a lot of money, Lee. All I have to do is sign this release. There it is. They're trying to get out with a quick, cheap settlement before the attorney gets involved, before exploring the true extent of this personal injury case. that insured may already have signed all your rights away.
Yeah, and subrogation is just, I mean, it's just that definitionally, we step into the shoes of our insured. We have no rights beyond what they have. So if they release our claim in the, vast majority of scenarios, we're just simply out of luck and we're stuck with nothing and are stuck with the fun aspect of going against that insured directly because they've agreed to defend and indemnify. And they've already spent the $5,000, right? They don't have that just sitting around. So we're out of luck. Yeah. So Lee, obviously, attorneys are very important when it comes to negotiating language and releases. Any thoughts on why it's so important to have an attorney that you can trust to actually review these things?
Yeah, having an attorney you can trust, he just cuts through the minutia. He can boil down the language, tells you exactly, here's what you're giving up in order to get that sum of money. Being able to spell out exactly the balance between what you're receiving versus what rights you possibly are giving up. They're able to see into the future, possibly the liability, the issues that this release might get you into. Let's say like the mold case. There might be future mold or mildew coming up, which this release will leave you on the hook for. Just having them have a candid understanding of the risks involved in the future. Lawyers are very good. We're very risk adverse. Any corporate lawyer will tell you this, that nobody likes them in the boardroom because they see all the risk. The CEO wants to go be big and bold, and the lawyer goes, whoa, 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 slow down, cowboy. Here's all the reasons why you shouldn't do that. And they're not telling you no. They're just making sure you understand the risks before you jump off the cliff and make this decision. Same goes for releases. Making sure you're understanding what you're giving up, what the release means, and if it's relatively risk-free to proceed with doing so.
Absolutely. So now, any tips that you have for adjusters or attorneys when they're negotiating specifically subrogation releases?
Number one, understanding which claims you own, making sure you're not releasing claims that you don't own. Like we've kind of been saying this whole podcast, ask the question. If indemnity is in there, ask for it to be removed. To be upfront about what you're looking for in the release and what you're wanting to be removed. There's no harm in asking. Oftentimes, this is just a form, cut and paste release language that defense counsel, they want this case to be done just as much as you do. They won't typically have any problem with indemnity. If they do start putting up walls, certainly get subrogation counsel involved. We can help tailor this or even make further arguments against indemnity language to make sure we're not caught in that tangled web of indemnity.
Yeah, and in MWL, we recently have a new program for clients. If anyone's interested and wants to reach out, where we'll actually review your releases, you can retain us to take a look at those case by case, review the releases, and give you our thoughts or help you negotiate those things. We also do trainings for clients. So if any clients wants us, Lee, myself, or one of our other attorneys, we'll come out, we'll speak with your team, we'll do trainings on, what to look for. Similar to this podcast, but way more in depth. And it's hugely important that folks get trained up on these things.
We make releases not be so painful.
Right. And we remove the wherefore art thou as well. So, a couple other clauses that I want to touch on before we wrap this thing up, just to toss it out there on the radar, is obviously we talked about, attorney fee clauses, being very careful there. There's tax implication clauses, right? Clauses that can allocate or have terms that would impact how taxes are going to be allocated, who owes what, which laws are going to apply and so forth. Hugely important. Look for those clauses. Another one is jury waiver and ARB clauses. Those can be a major problem. Lee, have you seen any of those ARB clauses that cause impacts?
I have. Our arbitration clauses seem to be everywhere in any sort of service agreement you'll enter into. Everyone seems to like ARB. It's a quick, cheap way to resolve a matter. I advise all my clients to try to steer as far away from ARB as you can get. It's really nothing more than a coin toss. Sorry for any ARB counsel that are listening. Or they don't follow the rules of evidence. The arbitrators are often not trained lawyers. They don't have experience in weighing evidence. And so really they're just reading these two clauses and saying, this one. I've had bad luck in arbitration for no reason and advise against it.
Perfect. And finally, choice of jurisdiction clauses, right? Many releases will have, this is subject to the laws of, Wisconsin, where we are, or subject to the laws of California. Interestingly enough, I actually deal with a lot of, not really related, but COGSA, so Carriage of Goods by Sea Act claims, where you can have any foreign jurisdiction clause, and it'll be like, the Holland courts in Holland or Great Britain or Ireland or wherever it is. And frankly, a lot of the marine carriers will include locations where not just the law is bad, but two, where it's just absolutely unfeasible to litigate a case unless it's, millions of dollars, Somali pirate courts, right? Whatever it could be. That's not actually a thing, but, they make it difficult. And that can be also the case for releases, where I've had plenty of cases where, there's absolutely, incident occurred in Wisconsin. The carriers are both out of maybe Hartford, and the insurance parties are all from the Midwest. And next thing you know, we have Louisiana as the forum state. So we always want to be careful, take a look at those things, because they can have an impact, right? And frankly, we should just be careful whenever something funny's in there. There's usually probably a reason for it.
Yeah, absolutely. I mean, choice of law, not only can it make it geographically difficult, like you mentioned, there's a reason they picked that state, that area, that choice of law. It's because that law is favorable to their position. Do what you can to steer around it, get into a neutral court or just the most reasonable court, so the court where the incident occurred.
Exactly. Now, Lee, anything else you want to touch on before we tie this thing up?
No, I really said what I want to say, but I can't stress enough. Make sure you're recognizing which claims you own during a release, making sure you're understanding the terms of the release, what the indemnity requires of you, what rights you're giving up. And if any questions, reach out. There's no harm asking the other side to remove that language, and no harm reaching out to MWL to give their thoughts.
Absolutely. Well, that's all we have for you today. Lee, thank you so much for joining. I'm sure we'll have you back. I think that talking about some of those other agreements, other issues that you talk about, the exculpatory agreements would be kind of a fascinating topic, future state. But either way, it's been a pleasure. Thank you so much, Lee. Thank you, audience. Excellent talking to y'all. This is the end of this podcast for the Subrogation Support Network. Your host, Ashton Kirsch, signing off. Thanks again for joining.